Okay, so you guys have introduced yourself. We have a number of general contractors who contract directly with the owner. We've got a number of subcontractors and a number of materials suppliers. My name is Jim Fullerton, and I like to call myself a bricklayer at law. I was originally a brick mason. I'm still a brick mason, although I work only for my wife now. And I built the house I live in now. I really enjoy brickwork, and recently built found monument at the entrance to my driveway, although that's largely because I overbought brick when I was building the house, and all the brick has been in the yard, and my wife's been after me to get rid of the brick for years, and now I've finally done that. Brick's a funny thing. If it's sitting in the yard over here, it's a problem. We have to get rid of it, but if you pick it up and move it across the yard and put mortar in between the brick, now it's a good thing. So the brick's no longer a problem, and the monument's pretty good. And I've been in I laid brick full-time for 4 years, I guess, I did it in high school, but then I did it full-time between college and law school, just because I wasn't in any big hurry to start that 30-year career. And I was a history major, and you know what they say about history majors. They either go into construction business or become teachers or become lawyers. And so I do all three pretty much. I was in the flooring business even earlier, since I was 12, and was in the flooring business for 10 years. I would do that in the wintertime and on the weekends when I wasn't laying brick. And that's how I met my wife, actually. I sold her a rug in 1978, and she is still paying for that. But that's worked out well for me, at least. So there's our email. Feel free to email any questions you have. I want to give you a short tour of the book because it's a way to talk about, what we're going to talk about today and what we're not going to talk about today, which is kind of the point. I want you to have some awareness of what's in the book that you can use another time. If you look at this table of contents summary, there's a chapter on credit management, which is things like the Fair Credit Reporting Act, the rules about running credit reports, the rules about Equal Credit Opportunity Act. This is credit management stuff that you probably know more about than I do. But I do have a few comments, particularly about the importance of security, and that's what we're going to start off with this morning. Then you got Chapter 2, Contracts, Terms, and Preserving Rights. We're going to spend a lot of time on that chapter today. What I am thinking is that we will start with the terms you want in your contract that you are sending to what I'll call the debtor. And you're the creditor in that instance. And I try to use those terms because everybody in this room at some point's a debtor and at some point's a creditor. A supplier, when they're selling materials, they're a creditor. When they're buying materials from the manufacturer, they're a debtor. And, the debtor and the creditor always have different needs or different desires in the transaction. So rather than offend anybody talking about those slime ball GCs or something like that, I try to just use the term creditor and debtor, and you guys, it just depends on which situation you're in. So the first thing we're going to talk about is what you want in your contract when you're a creditor. You're supplying labor and or material to somebody else. But then a lot of times the debtor's going to send you a contract and insist on using their form. That's reviewing and revising contracts that people give you. And those are what I was thinking we'd talk about today. The other choices, depending on the crowd, but we don't have time to do all of them is the problem, One is Uniform Commercial Code. FYI, every time you as a sub or a GC, every time you call a material supplier on the telephone, call Hajoka or whoever, and just order some material, you have a 20-page fine print contract, whether you know it or not. It's called the Uniform Commercial Code. Anytime there is a sale of goods, the terms of the UCC apply unless you otherwise agree. And so if the crowd's really heavy in suppliers, we'll often talk about that. But I'm thinking, and there is a chapter in the book I want you to know, that's chapter 4, Uniform Commercial Code, Sale of Goods. The other thing is chapter 3, Disadvantaged Business Enterprises. That was a very hot topic 5 or 10 years ago, and people wanted to talk about that a lot. In my experience, and I'm not really sure why, but it's just not as important to people as it used to be. And in any event, we don't have time to do all those things, so I was thinking in terms of letting you look at the book for chapter 3, Disadvantaged Business Enterprises, or chapter 4, Uniform Commercial Code, Sale of Goods, and we're going to spend our time talking about chapter 1 and 2, what you want in your contracts, and reading and revising contracts you get back. Chapter 5 is changes, delays, and other claims. That is a long chapter. We're going to touch on that a little bit late this morning, change orders, claims procedures in your contract, that sort of thing. But that's, it's got to be 50, 60 pages just about change orders, claims, delay claims, concealed conditions, those sorts of things that I know are important to you, but we could have a whole day, 6 hours, just talking about that subject. And I think all I can do for right now is let you know it's there. We will talk about it a little bit. UCC security agreements. The Uniform Commercial Code has 13 articles. And this causes a lot of confusion, so I'll just mention that. If you say UCC, people often automatically think, oh yeah, a financing statement, a UCC 1, Well, that's true, that is the UCC. That's Article 9, how you take a security interest in somebody's bulldozer or get a security interest in their accounts receivable. That is Chapter 6, Article 9 of the UCC. But the UCC also includes the sale of goods. That's Article 2. Banking transactions are covered by the UCC. There's a lot of different subjects in the UCC, and a lot of people don't understand that, so I just wanted to mention that. Then you'll probably notice more than half of the book is on mechanics, liens, and payment bond rights in the Mid-Atlantic region. And this is, I think, the best book on mechanics lien rights in Virginia, Maryland, DC, and Pennsylvania. It's certainly the longest. I don't think that's debatable. And that's what we're going to do all afternoon, I expect. And we'll start with the mechanics liens. It becomes harder to tell you exactly where we are in the book. The book is for the mechanics lien part. I'm going to try to tell you where we are when we're going through chapter 2, the contracts, but that's harder to do in the mechanics liens because I've learned the best way to teach mechanics liens is to talk about liens generally, because people have this idea that it's completely different in every state. And we don't have time, and I don't think it's really helpful to spend 2 hours talking about Virginia mechanics liens and then spend 2 hours talking about Maryland mechanics liens and then 2 hours talking about Pennsylvania, because 80% of the lien law is the same in all three states. And I think it makes it too confusing and it takes too long. I would encourage you to think in terms of getting a basic understanding of how liens work everywhere. And I'm going to try to highlight and we'll focus on the things that do vary from state to state, whether there is a defense of payment, what the priority of the lien is. Certainly, you can count them on one hand. Certain things are different, but I think it's better to spend most of our time talking about liens generally, then we'll focus on the 5 places that are different, and then we'll run through the states, how those states differ, Virginia, Maryland, DC, and Pennsylvania. Then payment bonds is the last thing we will do. There are, of course, performance bonds, bid bonds, payment bonds. I do all of those types of law, but today we're going to be talking about payment bonds, a mechanism to enforce payment, and the GCs in the world are generally defending against mechanics lien claims, and we do a lot of work on both of those things. So Chapter 17 is enforcement of judgment. You've gotten a judgment against somebody. How do you collect that? Garnishments, levies, debtors' interrogatories. It's just helpful background to you if you have a judgment and you want to know what to do with it. 18 is a lot of bankruptcy. We do a lot of bankruptcy preference work, which I sincerely spent 10 years trying hard to stay out of bankruptcy. I didn't like bankruptcy. It's complicated, very time consuming. I had a very hard time finding somebody that I could just give the work to because bankruptcy lawyers tend to be debtors lawyers. And if you're a creditor, you don't want a debtor's lawyer representing you. And the other thing we discovered over time is that the most common problem you guys will have are preference claims, where somebody you're doing business with has filed bankruptcy, and then 2 years later, the bankruptcy trustee is sending you a notice that you'll have to send in a check for all the money you received over the 90 days prior to the bankruptcy. And if this has never happened to you, I can assure you it's going to frustrate you extremely, because it may be the same debtor. You got burnt for a $100,000 account receivable when he filed bankruptcy, and that pretty much ruined your day. And then 2 years later, they're telling you got to send more money in. It really doesn't seem fair. And we discovered that defending preference claims is really the same thing we do every day enforcing mechanics lien rights. If you're sued for a preference claim, the first thing you should do, and the first thing we will do, is have a look at whether you had mechanics lien rights at the time you received the money, whether you had payment bond rights at the time you received the money. Did the trust fund statute apply? And if you had some kind of security mechanism like that at the time you received the payment, it's not a preference. I was not preferred over other creditors. I could have enforced those payment bond rights even after the bankruptcy was filed. So therefore, the trustee cannot make me pay that money back. And that works. It's really the same practice as our mechanics lien payment bond and trust fund collection practice, but it's just you never actually made the claim. So again, I just mostly want you to be aware that it's there. That's a very lengthy chapter 2, and that's something we do, although we're not going to spend much time talking about. Then you got a 50-state summary of mechanics lien law. We only wrote the Virginia, Maryland, DC portions of that. That's put together by a National Association of Credit Management, who also publishes this book. But if you need to know for whatever reason what a summary of the lien law in Idaho, that's where you can get it. Now, we also have a lot of appendices, which are at the back. And I'm also going to direct you to a number of these as we're talking, especially this morning. Some of them I gave you as separate handouts, but Appendix 1 is a credit agreement, the perfect credit agreement. That is what is used by a supplier. And if you look at the second page of that, the terms and conditions, that's what we're going to be talking about all morning, are those terms and conditions. Those terms reappear on Appendix 5, Proposal for Labor and Materials. I think I did print out a separate handout for you on that. This is what I'm going to suggest you put every bid you ever prepare, whether it's for materials or labor and materials. There are some differences, but not much. It's very similar. These will be the terms I'm going to suggest on every proposal you send to anybody as a creditor. And that's the first type of contract we're going to talk about. Then Appendix 6 is the same thing for a supplier. Appendix 7 is for equipment rental. Appendix 8 is a guarantee form. If you want to get a personal guarantee from somebody, you can also use this for corporate guarantees, the exact same form. You just put in the name of the corporation, comma, Inc., get it signed by their president. That is a guarantee. Appendix 9 is what most people would call a joint check agreement. I don't like to use that term, and it says project trust agreement. Judges don't like joint check agreements, and so I don't like to use that term. And I also think that you want to get some kind of security mechanism in your joint check agreement, whether it be an actual security interest, an assignment of the account receivable, or a trust fund agreement. And that's what this is a trust fund agreement. I hope I have a few minutes to talk about that as we go on. As a general contractor, Appendix 11 is the joint check agreement that you want to use as a debtor, as a GC. And it exemplifies how radically different the interests are of a creditor and a debtor. And it means that all of you need to know how to read joint check agreements and understand what they say and make sure you're using the right form. Same thing with waiver forms, which we are going to spend some time talking about today. There are no such thing as a standard lien waiver. They vary widely in how they're worded. And you'll notice, yes, actually Appendix 13 and 14. 13 is a lien waiver the way the creditor wants it, a supplier or a subcontractor. 14 is the way a GC wants it, the debtor wants it. And we will talk about that at some length later on. Then you start getting into mechanics lien forms that we will talk about this afternoon. There are bad check letters, if that would be helpful to you. All of this stuff is on the website also. Feel free to, well, everybody does, just take them, download them, use them. And, you know, if you need any help or get in any trouble, hopefully you just remember where you got them.